In French, renvoi means to return or send back. In conflict of laws, it's a doctrine directing the foreign court to adopt a foreign state's whole law, meaning both the state's substantive law and its choice of law rules. Renvoi can have dizzying effects. Forum choice of law rules might point to applying the law of a foreign jurisdiction. In turn, the foreign state's choice of law rules might point back at the forum's law. In re Estate of Damato, the decision of whether to recognize renvoi becomes critical in an inheritance matter. Joseph Damato lived in New Jersey, but he had business interests in Florida. He opened 2 savings accounts at a Florida bank. The accounts were opened in the name of Joseph Damato in trust for Philip Damato, one of Damato's sons. Apparently, he intended to create a Totten trust, a bank account created in the depositor's name as trustee for a beneficiary who receives the funds upon the depositor's death. When Damato died in 1960, the accounts contained nearly $17,000. Damato's son James became executor of Damato's estate, charged with distributing the assets according to his wishes. James petitioned a New Jersey probate court to instruct him on how to distribute the proceeds of the Florida accounts. The probate court faced the question of which jurisdiction's law to apply. The internal law of the jurisdictions differed. Internal law refers to the jurisdiction's substantive rules to decide matters on the merits, without regard to choice of law rules. Florida's internal law considered Totten trusts valid, so the proceeds would be distributed to Philip. New Jersey's internal law considered Totten trusts invalid because they didn't comply with testamentary formalities. Thus, the account proceeds wouldn't necessarily go to Philip. The court applied Florida's internal law in order that Philip receive the funds. James appealed to the New Jersey Superior Court, arguing that renvoi applied.